how to become a successful company lawyer, that means a corporate lawyer. It is a great honor and privilege for me to address before you as a special guest of this orientation certificate giving ceremony organized by Bangladesh Company Law Practitioners Society. You have gone through a training program on different sections of companies law, especially section 228, 229, 233, 241 of the Companies Act 1994. As a judge, I feel that I should say something about this. So, in a nutshell, I'll give some idea, some topic, some little bit tips on this matter. Regarding section 228 and 229 deals with amalgamation and merger. The following principles governing the amalgamation and merger of the companies. The scheme, there is a scheme you need to know that satisfies the requirements of law as prescribed in the section. The code, what we see, should the shareholders who may be affected by scheme have been fairly represented. We have to assess that. The scheme is passed by the majority of the shareholders in value. Also, the scheme should be in the interest of the shareholders of the transferor and the transfer company. Sanctions should be given to such a workable scheme which a man of business would reasonably approve. The court may impose conditions and modify the scheme if so required. The court may impose conditions and modify the scheme if, I have already mentioned that, sanctions should be given to a bona fide scheme which is fair as a whole to all concerned. The scheme should not only be the interest of the shareholders of the companies, but also in the public interest. So what is, in a concise way, you should have to have consent of majority shareholders and conduct a EGM with creditors and members. Mergers, acquisitions, and or restructuring plans require shareholders and court approval. So what is the effect of the scheme? Once the scheme is sanctioned and a certified copy of the scheme is filed with the register, it has a statutory force and cannot be varied by act of parties. This is all about section 228 and 229 in a nutshell. Then I next shift to section 233, protection of minority shareholders. This section is a vital safeguard for minority shareholders against the potential abuse of power by the majority. The key points on this matter is the purpose. It aims to prevent unfair or oppressive conduct by the majority, ensuring that minority shareholders are not disadvantaged. This protection is based on the principle that the majority should not act in a way that is unfair or oppressive to the minority. This concept is influenced by the English jurisprudence. It provides legal remedies to minority shareholders who have been unfairly prejudiced or oppressed by the majority's actions. A remedy under section 233 can be given only if the directors have acted in the breach of duty or if the company has breached any of its articles or any relevant agreement. Under section 233, the court can give the relief sought by the applicant or any other relief. The objective of the relief is to negate the impact of the prejudicial or other relevant misconduct on the part of the majority shareholders. So in an application under section 233, the main function of the court is not to see whether fraud is committed, but whether the resolutions adopted are unfair to the company and the minority shareholders. Now I shifted to section 241, which deals with circumstances in which company may be owned up by court, which you all gone through that there are 6 grounds which are as below. The company has by special resolution resolved that company be owned up by the court. Default in made in filing the statutory report or in holding the statutory meeting, or the company does not commence its business within a year, or the number of members is reduced, or the company is unable to pay its debt. The company is of the opinion that it is the last and equitable that the company should be owned up. You have to bear in mind that an application under Section 241 is a serious matter, and it amounts to like a killing of a company. On a close reading of Section 241, it appears that a petition for winding up should be considered, keeping in view the disadvantage of the shareholders. The winding up matter is a serious affair, which is evident from the perusal of entire Part 5 of the Act. And this connection, the anxiety of the Privy Council in the English jurisdiction in the case of unjustified winding up order may be noticed in any way. A limited company, being a juristic person, lives, runs, and functions under the provisions of a statute. Death warrant can be issued under the same statute. The death warrant in the form of winding up should be sparingly used. To the last minute, effort should be made to save a company from liquidation. So before considering Section 241, we have to think about all of these things. Now, how to become a successful company lawyer, that means a corporate lawyer. You know that bar and bench are two wings of a bird involved in the dispensation of justice. Both are supplementary and complementary to each other. To become a good company lawyer, that means a corporate lawyer, you must focus on developing strong technical skills in company law, contract law, corporate regulations, combined with strong commercial awareness and excellent communication abilities. Need to uphold professionalism and be prepared to work hard under pressure and prioritize continuous learning to stay current affairs with legal and business changes. Lawyers' primary responsibility to the court is to maintain respectful attitude and uphold the integrity of judicial process, which is paramount. This includes presenting cases honestly, not misquoting laws, and prioritizing the administration of justice over client interest when they conflict. Lawyers act as both advocates for their clients and officers of the court, with a duty to behave with integrity and fairness. So you have a duty to the court. You have gone through an exclusive training on company law matters. So you must maintain a respectful attitude, uphold the administration of justice, act with integrity, provide honest and accurate information to your client, avoid conflicts of interest, and you have a duty to your clients as well. Provide competent representation to your client, act in client's best interest. You have to think about it. Maintain client confidentiality, that's another thing. Account for funds. They must keep clear and accurate accounts of all money received on behalf of a client and pay it over promptly. Some ethical issues are there. You should follow the code of conduct of lawyers prescribed by Bar Council, uphold professional standards, exercise caution with media. Lawyers must exercise caution and professionalism when engaging with the media to avoid compromising the integrity of a case and to prevent potential contempt of court charges and to uphold the dignity of the court. Respect for the courts and colleagues. We all are part of the same family of justice. Maintaining a respectful or courteous attitude towards judges is essential to preserving the dignity of the judicial office. Similarly, professional courtesy towards fellow lawyers is important. duty to the public, our role extends beyond the courtroom. We have a broader social responsibility to protect, to defend the oppressed, and to contribute to public affairs. A lawyer's conduct must never bring disrepute to the profession, whose integrity is so vital to public confidence. Maintaining public trust is another important thing. So if someone wants to be a good lawyer, he must focus on developing strong communication, analytical, research skill while maintaining integrity and organization. Legal expertise, analytical and research skills, drafting and communication skills, advocacy and negotiation, and organization time management is very important. You have to learn how to manage your time. Active listening to your client is another thing. You have to think about it. Confidence is another thing. Be confident in your abilities, but also humble enough to ask for help when needed and work effectively under pressure. Networking is another thing to build a company law practice. Build a network with other professionals to build your practice and gain new opportunities. So from the above discussion, it is clear that lawyers must maintain the highest degree of honesty, integrity, and public confidence in the profession to be successful.